Professor Ben Saul is Challis Chair of International Law at the University of Sydney and the United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, and also one of the world's leading scholars in international law, counterterrorism law, international humanitarian law, and the law governing the use of force. So, Professor, in this conversation with the Human Rights Institute, University of Isfahan, HRIUI, we seek to examine the legal, humanitarian, and systematic implications of the recent US-Israeli aggression, US-Israeli war against Iran. We want to explore not only the legality of the use of force under United Nations Charter, but also the customary international law and the broader question concerning the erosion of the legal restraint on war. So first question will be about the UN Charter and how states should deal with it. So how would you legally characterize the United States and Israel military attack against Iran under Article 2.4 of the UN Charter? In your view, does this case represent a discrete violation of the rules on the use of force, or does it point to a more systematic weakening of the post-1945 legal order?
Thank you, and it's good to be with you. And certainly the Israeli and US invasion of Iran is illegal aggression under international law. It's a violation of the prohibition on the use of force, the prohibition on aggression under customary international law. It's not in self-defense because Iran was not attacking the US or Israel, and it wasn't authorized by the UN Security Council either. Now, I know that there have been claims of self-defense, for example, preemptive or anticipatory self-defense against Iran's nuclear program or Iran's support for groups like Hezbollah, as well as addressing the threat of Iran's ballistic missile program. But all of these are not legal reasons for using force under international law. A state can only use force in self-defense against an armed attack that is occurring or that is about to occur, that is imminent. And none of those conditions were satisfied by the situation presented by Iran. So look, this is a really clear violation of international law. Unfortunately, in this very sensitive area of international and national security concerns, unfortunately, there are violations of the prohibition on the use of force from time to time. This is a pretty egregious one, like, for example, Russia's invasion and aggression against Ukraine, because the US and Israel really haven't presented any serious legal reasons for this action and have felt themselves not really subject to much legal constraint at all. They just really assert that Iran is a threat to their security, and so they're going to use military force accordingly. The Trump administration has made clear it's not concerned about international law, and the US will be guided only by its own sense of morality or its own political judgment. So that is a new kind of threat to international law and to international order and the United Nations order that has sustained relative world peace for the last over 80 years now.
Thank you so much. In recent decades, powerful states have increasingly relied on concepts such as self-defense, as you mentioned, anticipatory action, preventive security, to kind of justify the use of force. And in the case of US-Israeli war against Iran, how should this claim be tested against the legal requirements of necessity, imminence, proportionality, attribution, and the absence of Security Council authorization? How should we justify this?
So if there is no armed attack or no imminent armed attack, then all of those other legal criteria are irrelevant. I mean, you don't have to talk about whether action is necessary or proportionate if there's no right to use force in the first place, because there's no armed attack. The question of imminence really, is an armed attack imminent? Is to a point a subjective judgment. I mean, there has to be, good evidence that another country is about to launch an attack. There's no magic time frame to imminence. It's not necessarily minutes or hours or even days, but there does have to be some, strong and credible evidence that a country has the intention to launch an attack in the near future. And of course, the US and Israel have not presented any evidence publicly or to the Security Council that Iran posed that kind of threat to them or to anybody else. So this is really a very clear and manifest violation of the most fundamental rules of international law.
Yeah, and it kind of risk transforming the exceptional legal doctrines into open-ended strategic justification. So all states can justify their behaviors, their policy in their own interest. Um, Next question is about your own experience as the special rapporteur on human rights and counterterrorism. How do you assess the use of counterterrorism narratives in interstate conflicts? In the context of the war against Iran, what are the risks of terrorism-related labels being used not only to justify military action, but also to expand sanctions, surveillance, information control, restriction of dissidents, and also the delegitimization of the alternative legal or humanitarian narratives?
Yeah, so labeling people or groups or even states sometimes as terrorist really serves two functions. One is a kind of political function. It's designed to delegitimize and discredit them, your adversaries politically. And unfortunately, that's been a very convenient strategy for too many countries in recent times, where the terrorist label has been alleged against members of civil society, journalists, human rights defenders, humanitarian organizations like UNRWA, the UN Relief Works in Palestine, Palestinian human rights organizations subject to sanctions. Russia, for example, has designated a major human rights group like which won a Nobel Prize as a terrorist or extremist organization. So lately, there have also been a small number of mainly Western states who have designated certain state actors as terrorists. Cuba, Venezuela, the Iranian Revolutionary Guards, and in doing so have violated certain other rules of international law, like the immunities of states before foreign domestic courts. So this is on the one hand, it's politically stigmatizing. On the other hand, it often unleashes lots of new legal powers, like criminal liabilities relating to membership or involvement with a particular group, law enforcement, intelligence, security powers of surveillance, arrest, detention. Powers to list organizations as terrorists in order to seize or freeze their assets, impose travel bans. And often this is abusive. I mean, yes, there are genuinely terrorist groups that are listed, but there are also many civil society groups that are deliberately targeted by states as a technique of political repression. So, unfortunately, this has grown since the 11 September 2001 terrorist attacks on the US. And in the last 25 years, the Security Council has required all countries to take lots of measures against terrorism, but hasn't been as strong in enforcing human rights protections. You mentioned humanitarians. I'd note lots of these very strict measures against terrorist financing, for example, have prevented foreign aid or humanitarian relief reaching civilian populations in need in the middle of armed conflict or even genocide sometimes. And so it has had some really serious effects on human rights. The right to liberty, privacy, the right to life in certain cases as well.
Yeah, exactly. And many human rights advocates warn that counterterrorism framework, when applied extensively, may blur the distinction between legitimate security concerns and the suppression of political, legal, and humanitarian critiques. That's the main issue, as you mentioned very well. Uh, Reports of attacks affecting residential areas, schools, healthcare facilities, energy frameworks, communication system, and other essential civilian infrastructure raise serious humanitarian concerns under international humanitarian law. How should the principle of distinction, proportionality, and feasible precaution be applied when attacking states kind of invoke dual use or security related claims to kind of justify the harm to civilian projects, civilian objects? Um, how should we assess this very hectic time?
So under international humanitarian law, civilians and civilian objects, like many of the things you mentioned, are protected and cannot ordinarily be the object of attack. Only military personnel and military objectives can be attacked. Now, having said that, sometimes objects that are usually civilian can also sometimes be used for military purposes or uses by military forces. And if that happens, then a set of rules on military targeting apply under international humanitarian law. So firstly, you have to establish that the civilian object is being used for some definite, concrete military purpose, not just some speculative or hypothetical future purpose. And secondly, if it is a genuinely military objective, then it can only be attacked if it would not, if doing so would not cause excessive civilian casualties. That means civilian people as well as civilian property and civilian uses of that object. So that does mean, for example, although there's no absolute prohibition on attacking hospitals, for example, if military personnel are using hospitals to carry out operations, it still might not be lawful to attack it if attacking it would cause too much civilian harm, because you'd you'd harm patients, medical personnel, you'd harm the medical facility itself, and therefore its ability to treat other civilians in future. It's the same with objects like energy or electricity or fuel, oil, roads, ports, bridges. I mean, all of these are very important to civilians. They can be used by military sometimes, but there has to be a very strong case for attacking those objects. And then even if you can attack it, there's still an obligation to minimize the civilian harm that would result from that attack.
Yeah, and particular concern has emerged regarding the reported attack on educational and scientific institutions in Iran. My own university have been attacked, and I'm sure you have heard the tragic and dark attack against primary school in Minab. So these instances should not be allowed to be happen.
as you mentioned, under international humanitarian law.